Mr Rossi.
Thank you, my Lord. My Lord, before going to El Khoury, can I give a reference that I should have had at my fingertips earlier in response to Lord Burrows, and I didn't, I'm afraid. It's on the question of telephone calls, and it's actually something that is addressed by Mr Justice Knowles at first instance, where he agrees with the view expressed by Mr Justice Stewart in Heiser, and you have the references page 205, where there's a quotation from paragraphs 147 and 148 of Heiser, where Mr Justice Stewart had set out the fact that in the ordinary private law jurisdiction context, a misrepresentation made by telex but received and acted upon within the jurisdiction, or a telephone call from outside the jurisdiction but answered in the jurisdiction, would lead to the conclusion that the substance of the tort occurred in the jurisdiction. But then Mr Justice Stewart said he found a difficulty with the submission that applied here, because Section 5 was not concerned with the substance of the tort, or where the substance of the tort is committed. And Mr Justice Knowles then agreed with that at paragraph 102 on page 206, but essentially adopted the second of my submissions on the point that I made to your Lordship earlier, that it didn't matter that didn't apply here, because what the claimants were complaining about were acts within the jurisdiction.
Yeah. Thank you very much.
And then, whilst I'm apologising, I should also apologise to my Lord Legate. He did not use the phrase common sense in El Khoury, as we are about to see.
I'm relieved to hear that.
What he did use was a phrase, the substance of the criminality, which may or may not have some impact here, we'll see. But he did not use the phrase common sense. Without being flippant on that point, though, and taking on board my Lord Burrows' concern and qualification about recourse to such terms, it's certainly the case that in the context of causation analysis, Clark and Lindsell describe recourse to judicial common sense as of utility in determining causal link, and the reference for that is 2-05 at page 3306 of the bundle, for what it's worth.
Sorry, 3306.
Thank
you.
So El Khoury, this is in the supplementary bundle at page 47, and the first point we would make about the El Khoury decision is that a degree of caution is appropriate, we would say, in reading too much from one statutory context to another, as a matter of basic principle. And that is particularly so in circumstances where the court in El Khoury emphasised that it was focused very specifically on the particular statutory context before it, and the wording of sections 1373 and 1374 of the Extradition Act, and what was described as the binary and mutually exclusive approach to location of the conduct, I emphasise again, obviously, the conduct that those sections adopted. And one gets that emphasis on binary and mutually exclusive nature and particular focus on these statutory provisions at paragraphs 18 and 53 and 64 and elsewhere in the judgments.
It's paragraph 51 I had in mind, I think, in El Khoury as
yes, my Lord.
showing that at least in that case the court started from a rather different linguistic position.
Yes, my Lord. So paragraph 51 and 56, your Lordship rejects Lord Hope's contemplation in the earlier decision, referred to at 30 and 49, that an act may be said to have occurred in a particular state if its intended harmful effects were felt there.
Or in 51, it's saying the word conduct would normally and naturally be understood as a synonym for acts done by the requested person in the specified location, and not as including effects
Yes, my lord.
felt in that location or of acts done somewhere else. So, I mean, of course, it can mean something different in a different context, but it makes it harder, to my mind at least, to say that it unambiguously means something different here.
My lord, we don't rely upon the kind of act-effect model that Lord Hope had in mind. We contend squarely that material acts occurred in the United Kingdom, as the Court of Appeal, we say, correctly found. And so we don't need, we say, to rely upon any abnormal or abnormally wide meaning of the words "an act" of the kind that your lordship considered was an abnormally wide meaning of the words "the conduct." We say we're in different territory here so far as the act affects.
I can't remember, but wasn't Lord Hope considering the sort of shooting across a border type of case? Or?
I'm sorry, my lord, I should know the answer to that question. I don't.
I thought that was exactly the... of course, it wasn't hacking of computers, but they were the kind of cross-border acts that were being discussed that are referred to in that United Nations commentary that you showed us.
Then I have...
The kind of posted box of chocolates and the explosion bomb sent and those sort of things.
So I have to, in that case, rely, my lord, upon two matters. Firstly, we say this isn't a classic transboundary case because we are able to point to what we characterise as actual conduct in the jurisdiction. And secondly, and alternatively, the dangers of read across from very particular provisions here to the State Immunity Act, which just has a single provision in Section 5. The other two respects, I said earlier, perhaps boldly, but I said earlier that this case had something for both sides, to some extent, to the extent it was relevant. We say it would have something for us in two respects. Firstly, in its focus for the purposes of determining where particular conduct occurs, its focus on the substance of where particular criminality occurred. We say taking that approach, and that's paragraph 64, where the focus on substance of criminality occurs. Here we say the substance of the wrongdoing complained of against Bahrain is alleged to have occurred in the UK.
The trouble was in El Khoury is that conduct, even if there was a course of conduct, it had to be either inside or outside the territory.
Exactly.
And therefore you had to find some way of, in the case where some acts were done in one place and some in another, of deciding into which box to put it.
That's your mutually exclusive.
Exactly. That's why it's a particularly difficult read across, we would say. But if one's focusing on an inquiry as to location of conduct and using as useful in that inquiry the question where has the substance of the criminality occurred, we say here, as the Court of Appeal put it, in fact, to paragraph 37, the essence of what Bahrain's agents are alleged to have done in the present case was done in the United Kingdom, where the claimant's computers were hacked. Now, it's right, I should say, for completeness, at paragraph 64, where your lordship's dealing with the question of substance of criminality, that the observation is also made that to satisfy the condition in subsection 3A that the conduct occurs in the territory of the requesting state, the person must be within the territory of the requesting state. Which is...
What worried? You said paragraph 64?
64, my lord, yes.
Right. Oh, yes, sorry. Thank you.
Which at first sight obviously isn't incredibly helpful for me on the presence requirement issue. But it doesn't really, we say, assist in the context of Section 5, because it's a comment so expressly focused on this particular legislation. And in El Khoury, we would respectfully submit it would have been surprising if, for example, the facts had been slightly different and the insider trading alleged in El Khoury had consisted of electronic trading on US markets from London, if that kind of conduct would not constitute conduct occurring in part in London and in part in the United States. And that appears to be what's contemplated, at least, in terms of a broader approach being possible at paragraphs 65 and 66, where your Lordship's contemplating the possibility of cases concerned with a course of conduct, some of which occurs inside, some of which occurs outside. And of course, we are here dealing with a course of conduct situation. The second point of at least potential assistance to us from this case comes from paragraph 57, just between G and H on page 65, where your Lordship holds that a statutory condition that conduct occur in a particular location did not require that all conduct occurred in that location. And that would, again, we say, to the extent it's useful and possible to read across from here, support the Court of Appeal's approach, as set out at paragraph 54 of its judgment, that it's irrelevant that some causative acts occurred elsewhere, provided at least a causative act occurred in the UK. So we respectfully submit El Khoury doesn't materially move the dial on the argument for those reasons. And subject to any further questions, I'll stop now and hand over to Professor Webb, if I may, to deal with divergence in the other respects.
Thank you, Mr. Rotting. Professor Webb.
My lords, my lady, there are a number of important respects in which, aside from Article 11, the SIA diverges from the European Convention on State Immunity. And several of
Professor
these...
Webb, forgive me, I'm going to ask you to move the
Microphone.
It doesn't amplify, in fact, but it does record
Okay,
answer.
no problem. Several of these are divergences that encroach on sovereign activity. So this analysis is relevant for two reasons. First, to rebut Bahrain's argument that the UK can only go further than the European Convention in making exceptions to immunity for private acts, but not for sovereign acts. When we look at the provisions of the State Immunity Act, we see that in addition to Section 5, there are exceptions to immunity in respect of sovereign acts that go beyond the European Convention. And this reinforces the starting point that a state is entitled to immunity in respect of some but not all sovereign acts. And the second relevant reason is it's part of our response to the Court's request for submissions on the relationship between Section 5 and Articles 11 and 15. If I could ask you please to turn to page 160 of the bundle, which is paragraph 63 of the judgment in the Court of Appeal. Lord Justice Males noted there that the State Immunity Act differs in various ways from the European Convention, and the divergence of Section 5 from Article 11 of the European Convention therefore comes as no surprise. You can see halfway through that paragraph 63, His Lordship refers to Section 3.1b, Section 4.1, and Section 8.1, as well as the provisions on enforcement of arbitration awards. I will address most of these provisions as well as Section 3.1a, Section 3.3, Section 9, and Section 12 of the State Immunity Act. I will deal first with the provisions that lift immunity for sovereign acts, and then with those that have a different jurisdictional nexus to the European Convention provisions. And just for your note, the provisions of the SIA that lift immunity for sovereign acts are Section 3.1b, Section 3.3a, and Section 3.3b, and Section 9. And those that provide for a different jurisdictional nexus to the European Convention are Section 3.1a.
Sorry, bear with 1 second.
Yes.
Different
Jurisdictional
jurisdictional
nexus.
nexus.
Section 3.1a, Section 4.1, and Section 9.
Thank you.
So the overarching point in this regard has been made in Argentum at paragraphs 29 to 30, and you don't need to turn it up. Mr. Otti has already taken you to this paragraph. And that is where Lord Lloyd-Jones and Lord Hamblin, the other lords agreeing, noted that the State Immunity Act departs in some respects from the European Convention in respect of the application of the distinction between acta iure imperi and acta iure gestionis, and also in other respects for jurisdictional connecting factors. So we can start with Section 3.1b, and if you want to have the text before you, it's 2135.
Sorry, 1.3.
2135 of the bundle. This is an exception that provides for an exception where there is an obligation by virtue of a contract, and as it expressly notes, whether a commercial transaction or not. There is no similar statement in Article 4 of the European Convention. And you don't need to turn it up because it's the absence of it, but that's at page 2531 of the bundle. Sorry. So we have in Section 3.1b.
Sorry, the Article 4 was...
2531.
Thank you very much. just bear with us for a moment.
Yes, I'm so sorry.
Not at all. Thank you.
So we have in Section 3.1b an example of expanding the exception in the European Convention in respect of sovereign acts. While we're on this provision, and you're on page 2135, you can see that Section 3.1b also differs in terms of the jurisdictional nexus. It provides that a state has no immunity in respect of a contractual obligation which falls to be performed wholly or partly in the United Kingdom. Article 4 of the European Convention is narrower because it contains no wholly or partly equivalent. Now, there hasn't been extensive judicial consideration of Section 3.1b of the State Immunity Act. The only case in which we know it's been invoked is the Tin Council litigation, which is not in the bundle. But just for your reference, and I'm sure you're very familiar with it, in that case, Lord Justice Kerr and Lord Justice Ralph Gibson in Obiter said that if the plaintiffs had been successful on their submissions, then they would have decided that they were not immune under Section 3.1b. So that's just an obiter comment that we have, but that provision was not excluded by any idea of the exercise of sovereign authority. Still on page 2135 of the bundle, we have Section 3.3. Section 3.3 defines commercial transaction in detail. Subparagraph A refers to an exception for any contract for the supply of goods or services. Section 3.3b provides for an exception for any loan or other transaction for the provision of finance, and so on. Importantly, subparagraphs A and B are not confined to activity into which a state enters or engages otherwise than in the exercise of sovereign authority. Those words, otherwise than in the exercise of sovereign authority, only appear in subparagraph C.
Yes.
The European Convention, on the other hand, does not define commercial activity. It has a reference in Article 7 and 6 to an activity in the same manner as a private person, but it does not define commercial or commercial activity as such. So we can see that the State Immunity Act definition of commercial transaction in sections 3.3a and b are broader than the European Convention and
Is C just simply, sorry to interrupt you, but is C not contemplating that the first two won't be in the exercise of sovereign authority, A and B won't be, because it's referring to any other transaction or activity?
My Lord, it hasn't been read in that way by the courts, and I will come to that.
Okay.
Yes. It has been read as only pertaining to C.
So that you could have a contract for the supply of goods or services entered into, could you, in the exercise of sovereign authority?
Yes, it would be unusual. Most cases are not going to be like that, but it is possible, and we do have some authority on that. Examples would be buying fighter jets, constructing a military base, printing banknotes, providing passport and consular services on behalf of a state. And I can come to some of these examples.
So your point is that section 3.3a and C,
A and B.
And B.
A and B, are broader than the corresponding provisions in...
Well, there is no corresponding provision in the European
But your
Convention.
point is that they include exercises of sovereign authority,
Exactly.
potentially.
Exactly. So, just to elaborate on my Lord's question about when this would occur, we can go to page 3065. This is Dicey. And you see the two illustrations.
Sorry, page?
3065. This is the extract from Dicey and Collins. And it's at margin note 9044, and it's the two illustrations, 1 and 2. Illustration 1 pertains to A, and illustration 2 to B, subparagraph B of section 3.3. So Dicey and Collins gives the example of an English company entering into a contract to supply arms to a foreign government. There would be no immunity because this is a contract for the supply of goods, and there's no test as to whether it's in the exercise of sovereign activity. Illustration 2 is regarding the guarantee of loans from one state to another, and you can see in the footnote at the bottom of the page, European Union and Syrian Arab Republic. Now, this case is not in our bundle. It is cited there in Dicey and Collins because this was a case in which Mr. Justice Bryan said he did not need to decide on the basis of section 3.3b because he instead found a waiver under section 2 of the State Immunity Act. But he noted that if Syria had challenged jurisdiction, section 3.3b would have removed its immunity for loans in the exercise of sovereign authority. And that's why that example is footnoted there in Dicey and Collins. Another case that considered but did not decide on the basis of these provisions is the Svenska case, which is in the bundle. It's at page 1911. This was a case in which a Swedish oil exploration company was in a joint venture with a Lithuanian state-owned company for the exploitation of natural resources. And Lithuania, as you can see at page 1911 at G, Lithuania had argued that it had immunity because it had entered into these arrangements in the exercise of sovereign authority. Now, the Court of Appeal did not need to decide this exact question under Section 33A because it considered that a joint venture agreement did not come within the definition of Section 33A. And you can see that at the top, the very top of page 1912. It found that the language of Section 33A was not apt to describe a joint venture agreement. So in the following paragraphs, the Court of Appeal instead turned to an analysis under Section 33C, and that is where they engaged in an analysis of whether this was in the exercise of sovereign authority or not. They did not engage in that exercise when deciding whether this came under Section 33A. Ultimately, they decided the case under Section 9.
Well, that doesn't show anything then, because they just didn't need to engage with that question.
Although, my lord, it would have been another reason why Section 33A did not apply.
Well,
And they
it
could
might
have-
have been or might not have been, but if you've got one reason.
Understood. But as I said, there's not extensive judicial consideration of this, so, but what there is consideration, we would say, is in favour of the respondents. And then finally on this point, and again, a case in which it wasn't necessary to decide it, but there is obiter in favour, is LR Avionics. This is at 1186. Paragraph 40, 6 lines down. This is Mr. Justice Mayles, as he then was. And he noted that a contract for the supply of services, and in this case it was passport and consular services to an embassy, will qualify as a commercial transaction even if it is entered into by a state in the exercise of sovereign authority. He accepts that this is at least possible. In the end, he didn't have to decide it because this was a case under Section 13. But again, it's acknowledging that the exercise of sovereign authority does not apply to Section 33A and 33B. Turning now to Section 9 of the State Immunity Act, and this is at page 2138. This is the arbitration exception, which provides that a state that has agreed in writing to submit a dispute which has arisen or may arise to arbitration is not immune as respects proceedings in the courts of the United Kingdom, which relate to that arbitration. This may be contrasted with Article 12 of the European Convention, which is at 2532. Where it expressly states that Article 12 of the European Convention will only apply to a dispute which has arisen or may arise out of a civil or commercial matter. So, unlike Article 12, Section 9 of the State Immunity Act does not need the dispute to be a civil or commercial matter. It applies to all arbitrations regardless of the nature of the underlying transaction, whereas the European Convention is limited to arbitration for civil and commercial matters. This has been confirmed in the Svenska case, page 1914. Around margin note B, the Court of Appeal notes that Section 9 is concerned with arbitration as the party's chosen means of resolving disputes rather than with the underlying transaction. So this means Section 9 applies to all types of underlying disputes. This is the interpretation in the UK. And according to Bahrain, this would not be permissible under their narrow view of any extension having to be for private acts. I would just note, while we're on Section 9 of the State Immunity Act, that unlike Article 12, it does not need the arbitration to take place in the UK or according to the law of the UK, and it also applies to a broader category of proceedings which relate to the arbitration. So it also diverges from the European Convention in those ways. I now turn to provisions that take different approaches to the jurisdictional nexus in and of themselves when compared with the European Convention. So section 3(1)A, this is at page 2135, removes immunity in respect of proceedings relating to a commercial transaction entered into by the state with no territorial nexus to the UK. This can be contrasted with Article 7 of the European Convention, which is at page 2530, which applies only if a state has on the territory of the state of the forum an office, agency, or other establishment, and the proceedings relate to the activity of that office, agency, or establishment. The broader effect of section 3(1)A was considered by this court in NML and Argentina. This is at page 1334.
Sorry, the page reference.
1334, in the middle of the page, noting that section 3(1)A was not qualified by any requirement for a link between the transaction
So
and the United Kingdom.
we're 1334, paragraph 37.
Paragraph 37.
37. Which letter?
Sorry, my lord.
Within paragraph 37, which part?
Within paragraph 37, it says that it's the third to the fourth line, not qualified by any requirement for a link between the transaction and the United Kingdom.
Yes. Thank you.
Also, in terms of differing jurisdictional connections, we have section 4(1) of the State Immunity Act, which is back at page 2135. This is on contracts of employment, and it provides for two possible links to the UK jurisdiction, where the contract was made in the United Kingdom or where the work is to be wholly or partly performed there. Article 5(1) of the European Convention, by contrast, has a different jurisdictional link. It provides where the contract of employment between the state and the individual has to be performed on the territory of the forum state.
I'm not quite sure I understood the relevance of your previous submissions about sovereign acts, but I'm not sure I follow the relevance of this, because the only argument against you is that the ability to diverge is limited in the case of sovereign acts. It's not otherwise suggested that there can't be a divergence, and all you're showing now is that there are some other divergences,
Yes,
which
my
on
lord.
the appellant's case, as well as yours, is not inconsistent with the
Right.
EWCA.
My lord, it is indeed a secondary argument. The main argument is the extension to the sovereign activity, but given that what's been an issue here is also the scope of the jurisdictional nexus and the difference between Article 11 and Section 5, it is of interest to note the different jurisdictional connecting factors that are in other provisions of the State Immunity Act. But you're right, this is a secondary point. And actually, Section 4(1) was my last point on that. Just for completeness, and again, not related to the private sovereign distinction or the scope of immunity from jurisdiction, the State Immunity Act also differs from the European Convention in relation to service requirements and in relation to immunity from execution. Again, this is just to show multiple ways in which we have divergence. In particular, on immunity from execution, Section 13 of the State Immunity Act is wider than Article 23 of the European Convention by expressly providing for enforcement proceedings against states and making specific provisions for EWCA parties.
Sorry, it expressly provides for Enforcement against states.
States and making specific provision for EWCA parties. In particular, Section 13.4, this is at pages 2141 to 2142, expressly permits execution against state-owned property which is in use or intended for use for commercial purposes, whereas Article 23 of the European Convention generally prohibits measures of execution against the property of a contracting state. And Article 6 provides an optional provision for states to lift immunity from property used exclusively in connection with commercial activities. So Section 13.4 of the State Immunity Act provides that it applies to property of a state party to the European Convention only if the process is for enforcing a judgment which is final under Section 18b and the state has made an Article 24 declaration, or if the process is for enforcing an arbitration award. So for that enforcement regime to be concerned, for it to be applicable to EWCA contracting states, it will be confined to Belgium, Luxembourg, Netherlands, and Switzerland that have made an Article 24 declaration, or to cases of the enforcement of an arbitral award. What's significant about this is that this divergence shows that where the UK wished to harmonise with the language of the European Convention, it expressly addressed and catered for that in the State Immunity Act. That's in Section 13.4. And no such language was used in respect of Section 5 of the State Immunity Act and Article 11 of the European Convention, indicating it was a deliberate divergence. So drawing the threads together, the State Immunity Act contains, in addition to Section 5, several provisions that depart from the European Convention by lifting immunity for sovereign acts and by taking a different, broader approach to any jurisdictional nexus. And if my lords and my lady have no further questions...
Sorry, could I just ask
Yes.
you to repeat the point about 13.4, did you say? Yeah, 13.
Yes, Section 13.4
Yeah.
provides...
To look at it, perhaps.
Yeah.
It's hard
This
to
is at
follow the point without
2141.
seeing it.
So it's page 2142.
2141.
Yeah. So those words are exact copies. Sorry, what was the point?
The point, it's a different point, my lord. The point is, if you look at the provision in Section 13.4 read with Section 18b, which also, Section 13.4 also refers to Article 24 of the Convention, you can see the State Immunity Act making specific provision for harmonisation with the European Convention in respect of enforcement, which it has not done in respect of Section 5 and Article 11.
Thank you very much.
So if there are no further questions, then Mr. Silverstone will address you on the Human Rights Act.
Thank you very much. Professor, we're most grateful to you. Mr. Silverstone.
My Lord, thank you. My Lady, the Respondents' submissions on the issues raised by the Respondents' notice are set out in our written case at paragraphs 8 and 88 to 106. As we have sought to explain there, the Respondents' case has three straightforward steps. First, there is no basis for concluding that international law requires the grant of immunity in respect of proceedings such as the present. Second, to afford immunity in such a case would therefore necessarily engage and breach Article 6 of the European Convention on Human Rights, applying the analysis of Lord Sumption at paragraph 34 of Ben Carbuche.
34.
Yes, my lord. And thirdly, Section 3 of the Human Rights Act therefore provides a powerful interpretative driver in favour of the respondent's case as to the meaning of Section 5. And we say the need to apply the approach under Section 3 applies at each stage of the interpretative exercise, not merely at the end, once all other issues have been decided, such that if the court harbours any doubt as to the construction of Section 5, it should adopt an interpretation which is compatible with the claimant's Article 6 rights. The appellant's response to this argument in its written case was to contend that it is a principle of customary international law that a state is entitled to immunity in respect of all acts, iure imperii, such that an exercise of jurisdiction in the present case would be in breach of customary international law. That appears at paragraphs 117 and 124 to 126 of its written case, where the appellant relies on Ben Carbuche and the jurisdictional immunities case for that purpose. However, as we understand the appellant's case as advanced orally yesterday, it no longer contends that there is a rule of customary international law that requires immunity in respect of all sovereign acts. Instead, for the purposes of the Section 3 Human Rights Act argument, it argues that it should succeed on the Human Rights Act issues because the respondents are unable to establish a rule of customary international law covering the facts of this case and permitting jurisdiction.
Isn't this the same argument that's already been addressed by Mr. Otti, but in a different context?
Yes, my lord, it is. And I will be brief for that reason, but it does arise in a slightly different way in my submission under the Human Rights Act position. And that's because we say that the appellant's position on this upends the reasoning in paragraph 34 of Ben Carbuche. The court's been taken to it, but if I may just go back to that paragraph at page 695.
Sorry, page?
695, my lord.
695, thank you.
Starting at A, international law is relevant to the operation of Article 6 because in accordance with Article 31(3)(c) of the Vienna Convention, the Human Rights Convention is interpreted in the light of any relevant rules of international law applicable in the relations between the parties. It is therefore necessary to ask what is the relevant rule of international law by reference to which Article 6 must be interpreted. The relevant rule is that if the foreign state is immune, then as the ICJ has confirmed in jurisdictional immunities, the forum state is not just entitled, but bound to give effect to that immunity. If the foreign state is not immune, there is no relevant rule of international law at all. What justifies the denial of access to a court is the international law obligation of the forum state to give effect to a justified assertion of immunity. A mere liberty to treat the foreign state as immune could not have that effect, because in that case, the denial of access would be a discretionary choice on the part of the forum state. To put the same point another way, if the legitimate purpose said to justify denying access to a court is compliance with international law, anything that goes further in that direction than international law requires is necessarily disproportionate. And we say, my lord, that it's clear from that passage that it is for the state seeking to justify a denial of access to court on immunity grounds to establish that such a denial is required as a matter of international law. And we say the appellant has not demonstrated that proposition.
What do you say to the argument that Ben Kabouche shows, or the approach adopted by Lord Sumption also shows, that prima facie exercises of sovereign authority are immune in international law, except where it's been established otherwise? I mean, that looks to be the thrust on page 705 of paragraph 52 leading into 53.
Yes, my lord. It's clear from paragraph 53 that Lord Sumption is focusing on employment claims, and that's of importance. He's particularly focusing on...
But the way he's got there is by saying that, well, there was never a consensus among nations between the absolute and the restrictive views. There was disagreement about that, but that is all presupposing that there is a consensus around the fact that sovereign acts are immune, but not when you go beyond that into the restrictive theory of private acts.
Yes, my lord.
I mean, looking at just beneath the letter C, where for at least 2 centuries has been a consensus in favour of some forms, the only consensus ever been is in favour of the restrictive doctrine, rather than the absolute doctrine. And so he isn't that where he gets the point that, on the face of it, sovereign acts are going to be immune, and that for employment, question of employment, you're going to have to then go into the question of whether it's a sovereign act or not a sovereign act, because you're then in the restrictive doctrine area.
Yes. My lord, if I may respond to that by starting at paragraph 37 of Lord Sumption's judgment,
Yeah.
which is in fact the passage specifically relied on by the appellant on this point. Heading, starting point, absolute or restrictive immunity. The fundamental difference between the parties to this appeal concerns the starting point. On the footing that customary international law must require the UK to treat Libya and Sudan as immune, the Secretary of State submits that it does. This is because in his submission, state immunity is absolute unless the case is brought within an internationally recognised exception to it. This submission, if it is correct, would considerably broaden the scope of state immunity in customary international law by extending it to any group of claimants about whom there was a diversity of state practice. But in my view, it is not correct. The rule of customary international law is that a state is entitled to immunity only in respect of acts done in the exercise of sovereign authority, in the absence of a special rule to some different effect, applicable to employees in the position of the claimants. That is the default position, and that, in a sense, is language not dissimilar to that which my lord has identified. What we say about that is that the key phrase, a state is entitled to immunity only in respect of acts done in the exercise of sovereign authority, while sufficient for the purposes of the discussion before him, in which there was a clearly recognised iure imperii, iure gestionis distinction for employment-related disputes, does not extend to this circumstance in which, as Mr. Otti has explained, there is no principle of restricting jurisdiction to iure gestionis acts, and therefore, in other words, when Lord Sumption says a state is entitled to immunity only in respect of acts done in the exercise of sovereign authority, what that meant was a state is entitled to immunity only, and even then not always, in respect of acts done in the exercise of sovereign authority.
Then, wouldn't you then need to show some internationally recognised exception from the default position in that area, which maybe you can show in some places?
My lord, the position, the correct analytical starting point we submit in this case is, as Mr. Otti has submitted, that a state is entitled to some but not all sovereign acts committed on the jurisdiction of a forum state where causative of personal injury. And on that basis, that is the starting point, and it is then for the appellant, in order to carve out an exception to Article 6, relying on a customary international law rule, to establish that there is a rule of customary international law that requires the grant of immunity in this case. So we would distinguish Ben Kabouche for that purpose, given that it concerned very clearly the employment context for which there were relevant principles relating to the jure imperii, jure gestionis distinction. But we would also submit that Lord Sumption's interpretation of paragraph 37 cover the analysis in this case. It's clearly for the state to identify a rule that requires the UK to recognise immunity.
So you would say that, read in its context, Lord Sumption's statement means that the sovereign character of the activity is necessary but not sufficient.
Precisely, my lord. So that's customary international law. As to treaty obligations, Bahrain accepts that the UK is not obliged as a matter of treaty law under the European Convention on State Immunity to accord immunity to it in this case, because of course it's not a party. So in our submission there is no basis on which to conclude that there is any rule requiring the grant of immunity in this case. The appellant also relies on paragraph 61 of the jurisdictional immunities case in this context. In our submission, that also doesn't advance its case. All paragraph 61 refers to is an agreement between the parties in that case that states are generally entitled to immunity in respect of acta jure imperii, but of course, as we've seen, there was no decision in that case that any form of sovereign act restriction applied or requirement applied as regards the grant of immunity for tortious conduct causative of personal injury on the territory of the forum state. So, my lord, neither Ben Kabouche in our submission nor the jurisdictional immunities case supports the existence of a customary international law requiring the grant of immunity. And the appellant doesn't contend that Article 11 of the European Convention or Article 12 of the UN Convention stand for a rule of customary international law. And so we say on
Do you
that...
contend that they do?
My lord, we don't, but we don't need to for these purposes in my submission.
I mean, what's the position in other torts, apart from personal injury and death, which is not referred to in the conventions? Let's say invasion of privacy. But why isn't it all at large on your approach in that area?
Well, my lord, we don't need to go that far for these purposes. No. We don't seek to make any submissions as to what the position would be if there were not a personal injury result from the tortious conduct. But it's clear in our submission that the starting point is that there is no customary international law rule requiring the grant of immunity for personal injuries committed on the foreign state territory.
Where there's physical presence, I mean, and we come back to that. Because apart from the conventions, there isn't any material that really bears on this question on the appeal.
Well, my lord, I'm not going to be able to go beyond what Mr. Otti has submitted in terms of the basis for the principle as we apply it. We do submit that in relation to Article 6, it's very clear that it is for the state to establish the rule of customary international law that justifies the departure from the right of access to court. My lord, in those circumstances, the strong interpretative obligation under Article 3 of the Human Rights Act operates in the respondent's favour, with the result that the exception under Section 5 in our submission must be read in the way it was construed by the Court of Appeal, that a foreign state does not have immunity for personal injury caused by an act in the United Kingdom, even if other causative acts take place abroad. I'm not going to take the court to the nature of the Section 3 obligation. The court's very familiar with it. It was summarised by my lady similar in the Mercer case, which is in the bundle at paragraphs 93 to 94. That's at page 1314. And applying that strong tool of interpretation, we submit that the Court of Appeal's construction was entirely possible. The appellant argues that such an interpretation would go against the grain of Section 5 because it would undermine the very purpose of the provision, which was, it says, to ensure consistency with the United Kingdom's treaty obligations under the European Convention on State Immunity. Our answer to that is, once again, to refer to Mr. Otti's submissions that there is no basis for concluding that Parliament intended to replicate Article 11 in Section 5, and in any event, by virtue of the UK's declaration under Article 24, there is no inconsistency between Article 11 and Section 5. And no other basis has been identified by the appellant for contending that Section 5, as interpreted by the Court of Appeal, would cut against the grain of the legislation as a whole. My Lord, for these reasons, we say that it is possible for the Court to adopt the interpretation of Section 5 reached by the Court of Appeal in accordance with Section 3 of the Human Rights Act, and the respondents invite the Court to take that course. Unless I can assist further, those are my submissions.
Thank you, Mr. Silverstone. We're very grateful to you. Mr. Hickman. We're ahead of schedule.
Sorry?
We're ahead of schedule.
Isn't it pleasing?
Yes.
I'll try and stay ahead of schedule. I began yesterday by stating our case quite simply. And I want to begin my reply by just seeing where we've got to. The State Immunity Act is intended to comply with the UK's obligations under the European Convention. And insofar as it's reasonably practical to interpret Section 5 consistently with the corresponding subject matter provision of the treaty, Article 11, it should and must be so interpreted. And the obligation arises from the Eschersheim, hasn't been disputed, that there is a mandatory obligation arising from that judgment, which was a unanimous judgment of the Appellate Committee of the House of Lords. And we say the submissions that you have heard over the last day and a half make it absolutely plain, first of all, that Section 5 cannot be said to be so clear and unambiguous that one doesn't need to. Cannot be said to be so clear and unambiguous that the Eschersheim principle is displaced. And it cannot be said that Section 5 is incapable of being read compatibly with Article 11. Mr. Otti began his submissions yesterday by giving some examples, and he returned repeatedly to the point about whether there is an act in the United Kingdom. And this is essentially his point one. What you are looking for, Mr. Otti said, is an act in the United Kingdom. He gave the example yesterday of a remote operating car. The remote operator being outside the United Kingdom causes it to crash. That would be an act in the United Kingdom, he said. Flying a drone into the United Kingdom causing damage, that would be an act in the United Kingdom, he said. But the question is not whether there is an act in the United Kingdom. The question is whether proceedings relate to personal injury caused by an act in the United Kingdom. Being hit by a drone or a careering motor car is not in itself tortious. To find out the act that has caused the personal injury, you have to trace the events up the causal chain until you meet a tortfeasor, at which point you stop the analysis. That is what Section 5 means, and that is why the relevant question is not, is there an act in the United Kingdom, but what was the act that caused the personal injury? And saying that every act that occurred between the conduct of the tortfeasor and the harm occurring is a causative act in some loose sense is not A, a helpful analysis, and B, most importantly, it's not the analysis that is required by Section 5. Mr. Ottey turned to the scheme of the Act, and he said that shows that their interpretation is correct. However, he has really no answer to the fact that there are provisions in the Act, which we pointed to, Section 3.1b being one that's been mentioned several times, which do refer to things occurring wholly or partly in the United Kingdom when Parliament wants to make that clear. It is said that there is an absence of a presence requirement. There is an express presence requirement in Article 11, and it is not there in Section 5. Ergo, Parliament intended to go further than Article 11, but that, with respect, is a non sequitur, does not follow. The presence requirement in Article 11 is plainly a belt and braces provision, because if you look at Article 11, the first part says that all the facts occasioning the injury must occur in the forum state, and there's then a presence requirement. It's a belt and braces provision. Parliament does not characteristically enact obviously unnecessary and duplicative provisions because it gives rise to endless arguments in cases in court to try and make each of the provisions have some independent meaning.
I thought it was to rule out the possibility of a trans-frontier situation. Isn't that what the commentary says?
That's the commentary. That's the commentary on the UN Convention.
Yes.
It is. I mean, I accept that it's there to rule that out, but it's belt and braces in Article 11. It's not necessarily belt and braces in Article 12, because Article 12 uses a different phraseology in the first part of the article. So, but my point is it's belt and braces under Article 11, and that's the background to the enactment of the SIA. The simple point is that Parliament did not need to include expressly a presence requirement because it did not need to, because that is the effect of the short, elegant, albeit decades down the line, it turns out, potentially ambiguous Section 5. It is next said that we are writing words in. It is said that we need to rely on initiating, precipitating, various other words that we've used in the course of our written and oral submissions. But we are not inviting the court to read any words in. Those words have been used in an illustrative way, in a way to try and explain the different meanings that Section 5 can have, and to try and explain why it ought to be afforded the meaning that we say it has. Our reading of Section 5 does not require any words to be read into Section 5 at all. You look at it and you apply it. By contrast, it has become clear in my submission that the Respondents' interpretation of Section 5 undoubtedly requires words to be read in. They really have no answer to the need to read in some form of de minimis exception, because it is clear that otherwise, on their analysis, if every event in the causal chain is an act, you do end up with a situation such as my Lord Burroughs presented in questioning both to myself and to Mr. Ottey, that a technological occurrence in the United Kingdom, or it could be something else, it could be somebody passing through the United Kingdom en route to another country where they commit a tort, or something of that nature, you do end up with a situation where a state could lose immunity in respect of a claim brought in the UK because one event has occurred in the United Kingdom in respect of a complex tort, even though the vast majority of the events have occurred elsewhere. And so one does have to, on the respondent's case, read in some kind of qualification, and that involves reading words into Section 5. In addition, as was clear from Mr. Ottey's submissions this morning, really does require some sort of reference to the substance of the tort or the essence of the tort. Mr. Ottey says, well, look at the facts of this case. Isn't it really the substance of the acts are occurring in the UK? This is where the essence of the acts, they're the words that are also used in their written case. But again, this is just a reintroduction through the back door of the test for jurisdiction or some other similar test, not jurisdiction in the state immunity sense, but for exerting jurisdiction through the gateway, the territorial gateway for the courts who are having jurisdiction, the substance of the tort, or this Stillier's approach that my Lord Lloyd Jones referred to. And so we do say that it involves reading words in, whereas our approach does not. Take a simple example, and I think the telephone call example that my Lord Legate gave is quite a useful petri dish for this issue, because there is no principled distinction between a telephone call and what's occurred here. Somebody sending digital signals down a line that create sounds in this country and that project sounds back up the other way. That's data. That is essentially what's being alleged in this case. Obviously, a more complex form of technological process, but in principle, there really is no distinction. If somebody engages in a phone call which results in somebody suffering psychiatric harm, the act that caused that harm is undoubtedly taking place abroad. That, in my submission, is clear. The technological process in between is not the cause of the harm. The fact that, on the facts of this particular case, those technological processes might be more complex and substantial does not change the basic principle. Mr. Ottey said in response to a question from my Lord Burroughs that he is not relying on a mere but-for-cause approach. An act has to be not too remote, not too peripheral, has to be common sense, reasonable objective view. This is my point. It involves glossing Section 5. There is some concept of substance of a tort, essence of a tort that is being introduced. The various secondary sources. Mr. Ottey went through the secondary sources and he said they don't really support the appellant's case. We say we do derive some support from them, although I hope I was modest in my reliance upon them. Certainly Lady Fox, in her article, is no support for my learned friend's case, because she squarely recognises that Section 5 operates in the way we say, and then she then goes on to adopt a substance of the tort test in order to widen it so that it would apply to something like bombings. But we actually say that supports our approach. But other than Lady Fox's article, there is, which we say, on properly read and analysed, is no support at all for the appellants and supports us. There is no support at all for the respondent's position. No support at all in any secondary source. You weren't shown a single secondary source which interprets Section 5 in the way that Mr. Otti contends, other than the recent publication, which is really just referring back to the judgments below. But can I just show you? Can we just turn that up? Because I didn't turn it up in my submissions. This is the end of the supplementary bundle. This is the recent book on state immunity, on which Mr. Otti relies. But if you turn to page 96 of the supplementary bundle, the way the authors approach Section 5 as a matter of principle is squarely supportive of our position. So at point 7, although the use of the indefinite article does make it more difficult to accept the submission that Section 5 does not apply if the claim relies on a series of harmful events occurring partly in the United Kingdom and partly abroad, there still appears room for argument that Parliament, in choosing this wording, had its focus on simple and not complex causative acts, and that against that background, the words "an act or omission" should be taken to refer to each and every act or omission causative of death, personal injury, damage of property, as the case may be, on which the claimant relies to found his claim, with the requirement imposed by Section 5 being that all of those acts or omissions can occur in the United Kingdom. They then do go on to say that they think the judgments below were correctly decided, but apparently on a misreading of those cases in which they appear to think they've decided that all of the acts occurred in the United Kingdom. But in any event, there's no support there at all in my submission for Mr. Otti. So there is nothing in the secondary sources that supports the respondents.
I wonder whether the authors there are using complex acts in a more specific sense. If you look at 8.20, the end of 8.20 on page 94, complex acts there refers to a single claim that the defendant is liable, where a single claim that the defendant is liable rests upon a series of acts and omissions occurring both within and outside the United Kingdom.
They're talking about a course, they're trying to draw a distinction between a course of conduct and a situation in which you might seek to characterise the same act as occurring in multiple places, operating in multiple places.
In my submission, that's the principled way to interpret it is the way we've interpreted it. If anything, I'd say that supports our case. In any event, it's no support for the respondent's position. And as my Lord Legate says, they acknowledge at the end in point 12 that it's all ambiguous. So goes back to my first point. If it's ambiguous, the Escherschein, you must interpret it in line with the UK's international obligations. Article 24.
So, yes, sorry, I was just looking at that. So that's at page 98, subparagraph 12.
Yes.
This is where they say there are reasonable arguments on each side.
Yes.
Yeah, thank you.
And
Can I just understand your submission on the Escherschein? Does it all come down to Article 24 and the effect of that? Or are you making a submission that where it's perhaps ambiguous as to whether the UK has relied on its derogation power or not, there's a presumption that it hasn't? Are you suggesting that? Or if you're not, then it seems to me all to come down to the effect of Article 24 here and as to whether there has been a derogation, or there can be a derogation or not.
Well, my Lord, I certainly wouldn't shy away from the point my Lord has just made. I certainly think that it would be a reasonable approach to construing the legislation to assume that it's in line with the European Convention on State Immunity. But we do say that Article 24 does not provide a basis for not construing the two provisions together, Section 5 and Article 11. And that is because Section 5 clearly does apply to some, well, at least it's been held to apply to some sovereign acts in the United Kingdom, al-Masrir, right? So this is the assassination type situation. So if you interpreted it more widely, it would without doubt prejudice the immunity of states in respect of sovereign acts. So you can't rely on Article 24 to say, oh, well, Parliament clearly would have intended. You don't have to apply the Eschershine principle on the basis that Article 24 means that Parliament might have intended to have a wider exception than contained in Article 11, because Parliament cannot widen the exception in Article 11 without treading on the toes of sovereign act immunity.
Do you say that that is so as a matter of the construction of Article 24, or do you accept that Article 24 requires you to look beyond it to see what sovereign acts are subject to immunity in customary international law? So
my submissions in response to Mr. Otti today are first of all that the relevance of Article 24, as we've just been having an exchange about, is as to the meaning of Section 5 and what Parliament intended in enacting Section 5. And the question then is, when Parliament enacted Section 5 in 1978, could it have thought that transboundary torts relating to sovereign acts of foreign states would not be caught by the restrictive doctrine of immunity? Of course it couldn't have thought that. The restrictive doctrine of immunity was firmly established. The sort of practice that my learned friend has referred to doesn't even begin to kick in, really, until around that time. The idea that Parliament could have intended in 1978 to have expanded the tort exception to include transboundary torts and not safe in the assumption that there was an exception to the customary international law rule of state immunity for sovereign acts is unreal in my submission. And that's the basic point. You've got to locate it as the Article 24 point, as a point that's relevant to the construction. You've got to think about what Parliament would have considered in 1978.
So just to be clear about this, I think the question being put to you, as I understood it, was if you leave aside the last sentence of Article 24, are you making a separate submission that in any event there needs to be harmony between Section 5 and Article 11? Or does one, in answering that, have to deal with the last sentence of Article 24?
So if Article 24 didn't have that last sentence, then I would still be standing here and saying, well, there are corresponding provisions, Article 11, Section 5, and you can rely on Article 11 as an aid to interpreting Section 5. But I have to accept that the really strong interpretive obligation that you get from the Eschershine is to ensure that the United Kingdom is not is a presumption that Parliament did not intend to breach its international obligations. And that's when Article 24, in the last sentence, really bites, because Parliament couldn't have enacted a provision establishing a tort exception to immunity that was wider than Article 11 based on Article 24 because of the last sentence of Article 24. And so that brings the Eschershine principle into play with full force, in my submission.
And just so I'm clear about this, you say that the final sentence of Article 24 prevents any further encroachment of non-immunity into areas of sovereign activity?
Well, my Lord, in a sense, that doesn't really matter, because what we're concerned about are the words Parliament used in 1978. So you have to interpret the statutory provision on the basis of what Parliament had in mind in 1978. Now, if in 20 years' time there's some development to customary international law and it becomes clear that wider exceptions to immunity are available, then perhaps Parliament could enact another provision which
Or even now it might.
widens, or now.
You say it's a different question what it can do now from what
Exactly.
it could do at the time.
So in that sense,
But my question is directed at the meaning of the last sentence of Article 24.
yes. Well, I accept.
Am I correctly understanding your position? You say that the effect of the last sentence is to prevent any further encroachment of non-immunity into areas which are concerned with sovereign activities of states.
Yes, yes, my lord. But I think I have to accept that if there are developments, that reservation would allow the United Kingdom in the future to potentially impose wider exceptions.
Well, if you're accepting that, does that mean you're accepting Mr. Otti's reading of it, that what it means is such immunity from jurisdiction in respect of sovereign acts as foreign states currently enjoy?
Well, I suppose my first argument would be that that is dealing with the situation at the time, currently enjoy.
At that time, but you would accept that construction, would you?
That would be my primary submission, but assuming that it can be given a wider analysis so that it could allow developments over time, it doesn't matter because Section 5 was enacted in 1978.
Yes.
And you say that the position at that time was that there was certainly no immunity in respect of tortious acts,
Transnational.
possibly at all in other countries, but certainly not where somebody wasn't physically present there.
Perfectly, my lord. Absolutely.
So in order to apply the final sentence of Article 24, you have to have regard to the extent of the immunities enjoyed by states in respect of their sovereign activities at the relevant time.
Well, that would be my primary submission. If it's a moving, as it were, if it allows developments of international law, so that it would allow the United Kingdom to change the position over time, then it still doesn't make any difference to my argument. That's my.
I think we were just trying to clarify because Mr. Otti had understood you to be submitting that there was no further room for inquiry beyond Article 24 because it was saying that, effectively, it was saying that where foreign states enjoy that there can be it was building in immunity from jurisdiction in respect of sovereign acts.
Yes, my lord. But I was.
You're not without the need to look at what the position is under customary law, but that was just a matter of construction of the section, and you're not maintaining that argument.
Well, you would have to look and see what the position was.
Yes.
Under customary international
Yes.
law. So in that sense, I am. But what I'm.
No, I understand.
I'm sorry. I was trying to deal with the.
Maybe you were never arguing the first point, but Mr. Otti thought you were, so I wanted to get clear what arguments we need to deal with and what we don't.
As it happens, we know that Section 5 was not enacted with, or was not. Sorry, I'll restart that sentence. As it happens, we know that the declaration in Article 24 was not made with Section 5 in mind, and I took you to the provision in the notes on clauses, and that's at 2271 in the bundle. And we know that Section 5 was not materially changed in its passage through Parliament. And you've got the relevant provisions, you've got the bill as introduced, and you see that from the bill as enacted. But even if I'm, as it were, wrong on all of that, Mr. Otti still has to show that there is an exception to the restrictive doctrine of immunity that would apply to this case and that would apply to transnational torts, which would permit Section 5 to be interpreted in such a way. Now, I've made my point about the fact the relevant point in time to look at this is 1978. But in any event, even if we're looking at it now, in my submission, Mr. Otti has not even begun to make that case. Now, can I deal first of all with the burden of proof, as it were, the burden of persuasion? The respondents say that it is for the Kingdom of Bahrain to establish the rule of customary international law that entitles it to immunity from sovereign acts. That is wrong. It is for the claimants to establish that an exception to immunity applies. In this case, that their case is within Section 5. Indeed, Section 1(2) of the State Immunity Act requires a court to afford immunity to a state, even if the state does not appear. So the idea that the state has to turn up and establish a customary international law rule is, in my submission, incorrect. Furthermore, the Kingdom of Bahrain is entitled to rely on the authority of Ben Kabouche, a unanimous judgment of this court, and one of the leading cases on customary international law and state immunity globally, for the proposition that there is a general or default, as it's put by Lord Sumption, rule of immunity for sovereign acts, based firmly on principle, the sovereign equality of states. And they're entitled to point to that to make their case. If there is some special rule, as Lord Sumption puts it in Ben Kabouche, that deviates from that general or default position, it is for the claimants to establish it. And we submit that that case has not been made, or has not even begun to be made. There is no law or statute that you have been shown which would allow this claim to proceed in the domestic courts of any foreign state. Mr. Otti showed you a number of statutory provisions, but they all reflect Article 11 or Article 12 of the UN Convention, or are built or are modelled on the UK legislation, or have been interpreted by the domestic courts of that state, such as in the United States and in Canada, in a way which would mean that this claim could not proceed in those courts. Insofar as there's any doubt about the position in Canada, I took you to the relevant passage where the court, we say, makes the relevant finding that their statute would not allow the Canadian courts to adjudicate on executive governmental decisions taken outside Canada in a foreign state. So there is no state practice at all. There's no laws, there is no case law, there is nothing, there was no secondary literature which you were shown, which is capable of showing that there is an exception to immunity that would apply to this case, or in any transnational case. Mr. Otti said that the International Court of Justice has drawn a line, as he put it, around military activities. That is not a correct reading of the ICJ's judgment. The ICJ proceeded and determined the point about military activities because it had to for the case. It did not in any sense suggest that that was the limit of state immunity. And in any event, as I explained in my submissions previously, the argument that there was an exception to state immunity was very firmly premised on Article 11, Article 12, the UK statute, all the other statutes that you've seen, none of which establish an exception for immunity for transnational torts. They all require the tortfeasor to be within the territory. Mr. Ottey says, well, that doesn't matter because there is an international customary law rule that recognises that the immunity of states does not apply where a tortfeasor is within the forum state. So the assassin example, he says, so states have gone that far, and as he put it, the pass has been sold. Or as my Lord Legate put it, all bets are off. But with my submission, that is flawed as a matter of principle. The international law materials and the US courts and all the case law that you've been shown draws a firm and principled line, and that line is that the tortfeasor has to be in the state where the tort occurs. And that is not arbitrary. Of course it has some, it can seem strange to a domestic lawyer that firing a missile into a state does not fall within the exception to immunity, but if the missile is fired from within the state, it does. But that is the line that has been clearly drawn.
As a matter of customary international law?
That is the line that's been drawn in the international law materials, in Article 11 and in Article 12, and in the case law of the US courts and in the other materials which I've shown you, the draft articles and so forth, commentary on them.
You say it's as far as the international law is developed in recognising an extraterritorial element.
Yes, I mean, what I don't say that now reflects customary international law, and I think Mr. Silverstone's maybe suggested that I had said that.
No.
And the Kingdom of Bahrain, I think it is important we make this clear, the Kingdom of Bahrain's position would be the same as Germany's position before the ICJ, in that there isn't even a customary international law exception to immunity in respect of tortfeasors within the jurisdiction. But my point is you do not need to decide that, because it doesn't arise on this case. But that is the position of the Kingdom of Bahrain, same as Federal Republic of Germany. Now, in relation to that, my Lord Legate said it was important to this case. So I have some very short submissions on it, but I want to premise them with this point that this court does not need to determine them. So the submissions would simply be this. I've produced a note. I'm going to read it out, but if you will permit me, I'll send it to you as well after I've read it out. I can give it to Mr. Ottey now.
Well, we don't normally receive speaking notes, but
no. Well, in which case I won't send it to you.
How extensive is it?
I just thought it might be helpful, but I'm happy to.
How extensive is it?
How expensive?
Extensive. I'm sure it's very expensive.
No, it's not very expensive. It's 2.5 pages. The first page really makes the point I've just made, which is that the court doesn't need to deal with this point because the issue doesn't arise. But since I was told you might require submissions on it, and because Lord Legate says in his view it's important, at least for him. But if you don't want me to, of course I won't.
Are we getting a transcript anyway, or not, of the hearing? Sometimes we get sent a transcript, sometimes we don't.
Right, we'll admit it.
Yeah.
Okay, I'm grateful, my lord. In which case, I probably don't need to read it out. I mean, the basic points are that there are 193 states. The ratifications of EWCA are relatively small in number. The UN Convention has not attracted wide acceptance, and it hasn't been ratified by very many countries and hasn't come into effect. There is, in the commentary to draft Article 12, at footnote 148, the International Law Commission referred to the Survey of State Practice, which we feel you probably should see. So if you don't mind, I'll send you that. That report noted that the practice in Article 12 was in its infancy in 1983.
Am I right in thinking that the European Court of Human Rights in these immunity cases has treated the UN Convention as a source of customary international law?
No, it hasn't gone that far, my lord. Perhaps I can show you. There is one case. We refer to it in our written case. It's in the court bond 2478. It's JC. So this was a case against the Holy See by some appellants who had suffered child abuse at the hands of priests, and they claimed that the Holy See was responsible. And the Belgian courts found that there was immunity, and one of the bases on which they found there was immunity was on the basis of Article 12 of EWCA. And the court looked at that in an allegation that there was a violation of Article 6, and it accepted that the application of that rule meant that there was no violation of Article 6 because it reflected a reasonable position, and it wasn't manifestly unreasonable. But they didn't go as far as to say that it reflected state practice. I'm sorry, I've got the wrong bundle. It's 2458. Paragraphs.
Two, 4, 5, 8 is McElhinney and Ireland.
Yeah, wrong reference. Sorry, there's a wrong reference in the note. 2469, I'm so sorry.
That's the start of the case in French.
That's the start of the case. The,
Yes.
no, that's the French version.
French text.
Yes. Sorry, my lord, it's 2516 is the relevant passage. I'm sorry, it's in French and then it's in English in translation.
Is this an official translation? Professional but not official.
That's right.
Professional but not official. Yes, thank you very much. Just so we know.
So perhaps I can just ask you to read 68 and 69 on 2516. Sorry, and you need to read 66 and 67, sorry, to make real sense of those.
So
66 and 67.
can you tell us what is the point that you're making on?
Well, the court basically finds that falling under the exception in Article 11 justifies the interference with Article 6, but it doesn't say that it reflects customary international law.
But I thought that the principle was that the immunity had to be required by international law in order to be justified.
The European Court of Human Rights has applied that principle in a slightly different way. So it recognised that exception was justified in that case, but it didn't go as far as to say it was required by customary international law.
So it's just those paragraphs you're referring
Yeah,
to?
66 through to the
67
end
to
of the...
69.
Yes,
Yeah, thank you.
66 through to the end of the...
66.
In relation to the Foreign Act of State doctrine and the case we looked at on that, we do say that's not relevant. We don't say that it, as Mr. Ottey put it, draws the sting from points about comity. Comity loomed very large in that case, and obviously it was an exceptional case. Recognising an exception to state immunity is something of a different order. Then in relation to the differences between the European Convention and the State Immunity Act, just so that you have it, we do deal with these in our written case at paragraphs 85 to 91, and that's in the key documents bundle at 83 through to 85. And in response to what Professor Webb has said today, I just make the following short points. That Section 3.1 of the Act corresponds to Article 4. And insofar as there's any overlap into sovereign acts, then it's there in Article 4. Section 3.3, we say, is a provision that was brought in by reference to Article 24, and it may well be, if the issue needs to be argued, that it has to be interpreted consistently with Article 24 in a similar way that we're arguing in this case. But it doesn't provide any material for the respondents. Section 9, as far as we can see, has not been held to apply to sovereign acts. It has, in the Savinska, which you were taken to, been applied to a different connecting factor than under EWCA. But again, we see no reason why that shouldn't be covered by Article 24. And it appears that it's related to the fact that the connecting factors are justified under the New York Convention, and you get that from paragraph 120 of the judgment at 1989, and all of the signatories of EWCA, signatories of the New York Convention. It's paragraph 120.
Thank you.
And again, we say NML capital does not advance matters for essentially the same reasons. In relation to section 13.4, we deal with this in our written case at paragraph 90 at page 85 of the key documents bundle. And we rely on it, as it were, as demonstrating that Parliament did intend to ensure that it complied with its international obligations under the European Convention on State Immunity. So, whereas Professor Webb says, well, here's Parliament very expressly making sure that it's in line with the European Convention, we say, well, that's what Parliament intended throughout the Act, unless it was a provision that fell within Article 24. And as you will see, in relation to those provisions, they did require rather specific treatment. So we don't say that assists the respondents, and if anything, it assists our submissions. Can I turn then to respondents' notice point very finally? The burden of proof issue arises in a somewhat different fashion in relation to the respondents' notice point, because if the respondents are correct, essentially in any case in which a state is subject to a claim in the domestic courts of this country in which it raises a state immunity issue, it has a burden then to discharge to prove that it would, under customary international law, have immunity. Otherwise, it will find that there's a breach of Article 6 and the relevant provision of the State Immunity Act may be read down. And given that you're talking about immunity, it would be most peculiar if a state was subject to that level of obligation. But we do say, in any event, that all the relevant materials are before the court. The court has extensive materials on the tort exception in state practice, legislation, judicial decisions from numerous different countries. And so if there's a burden to discharge, we have discharged it. Ben Kabouche we rely on firmly, and we say if there is no state practice which deviates from the rule of sovereign immunity for acts iuri imperii in respect of transnational torts. There is none. And we can't be expected to do any more than that. We can't be expected to show that claims have not been brought in various countries because it was apparent they would not succeed and would be struck out. What we can do is identify claims that have been brought and have been struck out, and you have those. And so we don't have a burden to discharge, but if we do, we have discharged it. Section 3, the argument was made, well, it wouldn't cut across the grain of the legislation to interpret it in the way that the courts below have interpreted Section 5. But the whole premise of that submission was that you don't have to interpret it consistently with the UK's international obligations. If we're right, the premise of the Respondents' notice is we're right that you do have to interpret Section 5. So if we're right on that, you can't use Section 3, as it were, to reinstate the Court of Appeal's analysis, because that would be cutting directly against the grain of the legislation. Miles, can I just check if there's anything that anyone would like me to
Yes, of course.
make? My lords, my lady, unless there are any more questions, those are my submissions.
I don't think so. So now you're going to put in your short note,
I will put that in, given that you've given me permission.
and Mr. Rotty should have an opportunity to respond to that. 7 days, Mr. Rotty?
Thank you very much, my lord, yes.
I don't know, Mr. Rotty, if there's anything you want to say in relation to the authority that's been cited in reply, JC in Belgium.
Could we do that at the same time, my lord?
Yes.
If that would be acceptable. Thank you very much.
Thank you. Well, thank you all very much. We're very grateful to all counsel for their written and oral submissions in this complex and important matter. And we're also very grateful to those sitting behind you for the great care that's been shown in the preparation of the case for the hearing. We will take time to consider our decision. Court is now adjourned. Thank you all very much.